All rise. The Court of Appeals Division 1 is now in session.
Thank you, counsel. Please be seated. As an initial matter, anybody who feels comfortable doing so, please feel free to remove your mask. We are now here for oral argument in CV20-0138, Jago Holdings versus Stevens et al. As you both may be familiar, we record and live stream these proceedings, so when you speak, please announce your name and the name of the client that you're representing. According to our current protocols, you will be arguing from counsel table. Please feel free to do that however you feel most comfortable. Stand up, sit down. The countdown clock is still on the podium, however, so we'll do our best to run that in a way that you can see it. I'll try to give you some signposts, but you still have a maximum of 20 minutes, which you are not obligated to use, but you should feel free to do so. If you are planning to reserve some time for rebuttal, that is your responsibility to keep that. Do keep in mind we have read all of the briefing, we have reviewed the record, we have conferenced the case, so we've discussed it this morning. And so with that, please feel free to proceed.
Thank you, Your Honors. May it please the Court, Aaron Finter appearing on behalf of the appellant defendant Jago Holdings, LLC. As the Court is aware, this case concerns a dispute over the distribution of commissions generated from the sale of CenturyLink services. I believe the plaintiffs' appellees have a tendency to kind of muddy the waters on those relationships, so I want to address that just briefly. I think it's quite clear that the top of the pyramid here is CenturyLink. That's the carrier. That's who has a direct contractual relationship with its customers. CenturyLink pays commissions to its contracted master agents. In this case, that is Intelisys is the contracted master agent. Under that, the master agent, there are sub-agents. Jago Holdings is a sub-agent under Intelisys in this case. I think that's important because the plaintiffs in this case have no direct contractual relationship or agreements with either CenturyLink or Intelisys, the master agent, or any other master agent. Their claim that they're entitled to some compensation is derived from the oral contract they allege exists between the plaintiffs and Jago Holdings. The plaintiffs' arguments for purpose of the preliminary injunction hearing were based in large part on a report that was prepared by CenturyLink detailing commissions. And the plaintiff's argument was that this is their smoking gun because it lists rep IDs that they claim belong to the plaintiffs. They've since retracted that in part and admitted that, in fact, there are no rep IDs associated with Tim Stevens or Mark Stevens on that report. Any such rep IDs would be associated with marketing support services. But what was important was that Larry Floyd, the sales commission manager at CenturyLink, clarified is that CenturyLink doesn't have an opinion as to whether or not the plaintiffs are entitled to any compensation, and they wouldn't know either way because CenturyLink's only obligation is to pay its contracted master agents. Once that payment is made, CenturyLink is done. So CenturyLink doesn't receive copies of any agreements between its master agents and their lower tiered sub-agents like Jago Holdings in this case. So they wouldn't have any information as far as what obligations there are of a sub-agent to generate a commission, what the amount of the commission would be, or what accounts that specific agent is going to get paid on. The plaintiff's allegations are that as far back as the 1990s, Tim Stevens was selling services for one of CenturyLink's predecessor companies, and that they are essentially entitled to a never-ending flow of commissions that are generated from any sales made to those companies now by Jago Holdings, despite the fact that they have no involvement in the placement of any of those orders, the negotiation of any of those contracts, or don't maintain any current relationship with any of those companies. Our primary argument for purposes of preliminary injunction is that you are not entitled to a preliminary injunction where you are seeking solely monetary damages. And I don't think that there is any dispute in this case that what the plaintiffs are seeking are monetary damages. And in fact, in their complaint, in the prayer for relief, they seek a money judgment, an amount to be determined at trial. In their amended complaint, they seek a money judgment, an amount to be determined at trial. And in fact, in their answering brief on page 53, the plaintiffs' appellees admit that in fact they are seeking monetary damages in this case. So I don't think there's any dispute on that issue.
So what is your understanding of why the trial court granted the preliminary injunction then, if it is only for monetary damages?
There aren't any specific findings, Your Honor, so I can't tell you. I think, in my mind, it was pretty clear, and I know that the plaintiffs have sought to characterize the monetary damages as their quote-unquote property, and perhaps that was some basis, but at the end of the day, the property we're talking about is not a car, it's not a house, it's not a watch, it's money. Intelisys, as the master agent, makes one payment of commissions to Jago Holdings, my client, each month. And what the plaintiffs are saying is some portion of that money should be paid to us. If the plaintiffs were ultimately successful in this case, what they will receive is a judgment that says they're entitled to some amount of money. This is not a case where they have some sort of an ownership or relationship with any of the underlying CenturyLink customers. They're not going to get a customer somehow out of this lawsuit. They're going to get money. That's it. Because neither my client nor the plaintiffs have any rights to those customers, because that's something that CenturyLink gives directly to its master agent, the only one they have a relationship with.
Now, assume that you carry the day with that. Do any of the other issues matter, or does that resolve it? If it's money, we don't give preliminary injunctions for money generally. Are we done?
Essentially, yes. I think that's the clearest path for this court to find that there was a reversible error, because I think it's the simplest issue, and I think it's well established under Arizona law. And
Does this case fit any of the exceptions for when we might allow it for money?
No, because the only exception that the plaintiffs have brought up is in the HiQ Labs case, which deals with a case where the argument was, well, if we don't get the injunction, then it's going to shut down our business. Well, the evidence presented is the plaintiffs have no ongoing business. They have no employees. They have no relationships with any customers. They have no relationship with any master agents, and that's important because you only get paid if you have that relationship, because you have to place orders through a master agent. They're not going to be able to go directly to CenturyLink. So this isn't a case where there was any evidence that there was a possibility that they were going to be put out of business, because all of the evidence, and they don't dispute it, they were honest about it, is we don't transact any business. So the plaintiffs haven't identified any of the exceptions to the general rule that you don't get a preliminary injunction if what you're seeking are monetary damages, because there is no irreparable injury in those cases, which would be necessary to establish. Again, I mean, what this is really about, we would submit to the court, is that the plaintiffs are seeking to create a treasure chest so that if they're ultimately successful, they can collect from it. The problem with that is the purpose of a preliminary injunction is not to help ensure that the prevailing party is able to collect in litigation. It's to preserve the status quo. And so in this case, what they're seeking to do is to create a source that they can recover from. Well, that's not the purpose of a preliminary injunction, I would submit to the court.
Counsel, you have 13 minutes.
Thank you. Collectability is always an issue in most all civil cases, and it's not a basis for the imposition of a preliminary injunction, because if the court were to accept that argument, that would mean in essentially any breach of contract case where someone said, I performed a service, you agreed to pay me some amount of money, that party would then be entitled to go out and get a preliminary injunction so that they would have some funds out there to collect against. Well, that's just not Arizona law. And in fact, that's the only way. If this court were to find that were to apply, then essentially every breach of contract case is a case where someone could go out and get a preliminary injunction. It is our position, and we submit to this court, that the plaintiff's true reason for getting the injunction was twofold. One, to have a source to collect from, and two, to make it more difficult for the defendant to afford to defend himself against their claims in the litigation. So we believe there's some tactical reasons for what they've done. And I again submit that that is not a good reason for the imposition of a preliminary injunction in this case. With regard to a strong likelihood of success, we rely heavily on the Rudinsky case, which I think is factually extremely similar to the facts of this case. There, Ms. Rudinsky was seeking a commission from the defendant. Her argument was, I directed some clients to you, and you have to pay me a commission if they buy anything from you or you generate any commissions at any point in the future, which is exactly what the plaintiffs in this case are saying. And in that case, the court held that, in fact, the statute of frauds did apply because it's a contract that wasn't going to be completed in less than a year. She made an argument for part performance, which was rejected because, again, we're just talking about monetary damages, and you don't get part performance doesn't come in if it's just monetary damages. And so I would submit to this court that, the Rudinsky case is about as close as you're ever going to get factually to the facts of this case, where someone is saying that I did some work at some point in the past, that's all I have to do, and if you generate any income from something that I did in 1990 at any point in the future, you have to pay me. Despite the fact, and this is, again, when the plaintiffs, to craft their arguments, kind of muddy the water between the parties. Because what they're actually saying is, we did work under Alpha Communications, another master agent. We did some work under Vital Telecommunications, another master agent. And somehow Jago Holdings, who has never been a master agent, who is a sub-agent, has to pay us going forward in the future for work we didn't perform for Jago Holdings, for work we performed for another company. So that is, I would say, a very strained argument because, again, the plaintiffs have no ownership over these accounts. The best evidence of that is kind of goes along with our consideration argument, or lack of thereof, is that the plaintiffs are arguing that, hey, we have a contract, we provided you with these customers, and you're generating income from it. The problem is, in their answering brief, they've retracted that somewhat and admitted, okay, we didn't actually provide you with any customers. And they have to admit it because the evidence that was presented is that Vital Telecommunications, who was a master agent under CenturyLink, transferred those very accounts to Intelisys, which is the current master agent that has all those accounts. That was not done with the plaintiff's consent. It wasn't done with Jago Holdings' consent because their consent isn't required. And after all of the accounts at issue were transferred over to Intelisys, Jago Holdings entered into a contract to service all those accounts for Intelisys. That's why Jago Holdings is being paid today. It has nothing to do with any work that the plaintiffs may or may not have done in 1990 for some other company. And I think the best evidence that they have no ownership over those accounts and could transfer nothing is the very fact that they didn't even know the transfer happened until the filing of this lawsuit. They weren't even aware that those accounts have been transferred from one master agent to another. Because again, CenturyLink doesn't require their consent for that. Which then brings up the issue, the plaintiffs in this litigation have claimed that they were a independent sales agent of Jago Holdings. The problem is there's never been any evidence that they've actually sold anything for Jago Holdings. All the evidence is the only one who does any work is Jago Holdings. The only one who has any relationship with any alleged customers is Jago Holdings. So this begs the question of, if you had a contract and you think there was consideration, what did you provide? What of value did you provide? And the answer is nothing. There's no evidence they provided anything of value. Because again, they can't provide the actual accounts. They don't have the right to that. So what did they provide? I think the answer is they provided nothing. They have nothing to give. They don't have a right to the accounts. They haven't placed any orders. And they have no current relationship with any of these companies that they say make up their alleged book of business. So there's essentially nothing for them to give. With regard to the balance of hardships, Jago is the one that negotiated every current contract, placed every order through Intelisys pursuant to its written agreement with Intelisys, which is why it's receiving compensation today. So there is no hardship on the part of the plaintiffs. They haven't done anything, and they haven't done anything in many years to generate any compensation. And their claim that their hardship is, well, we don't receive any money on a monthly basis going forward. Well, the injunction doesn't solve that problem because the money is getting paid into the court. It's not getting paid to the plaintiffs. So if their hardship is, well, we don't get any money on a monthly basis, well, the injunction does nothing to solve that. All it does is create a situation where my client, Jago Holdings, is working on a month-to-month basis, dealing with all these clients pursuant to its agreement with Intelisys, because otherwise my client won't get paid if it ceases doing the work, and it doesn't get all of the money from its labors. So the only hardship here is the hardship on my client. With regard to the issue of security, Plaintiffs admit that the issue of the proper amount of security under Rule 65 was actually never addressed by the trial court. There was no hearing or other proceeding to address what the appropriate amount of security would be to protect my client in the event that Jago Holdings was found to have been wrongfully enjoined. The plaintiff's only argument is that the trial court's silence must have meant that it was, its opinion was that there was no amount of money necessary. I would submit that that's nowhere in the record. There is no record to support that position. And that the plaintiff's second argument on that issue is that essentially the money that's being deposited in the court is the security. Well, that's not the security. To the extent my client has any carrying costs, interest, or any other expenses, as a result of not having access to the funds that it's generating from its work, it's going to have damages, and just giving the money back won't solve that problem. And I'd like to reserve the rest of my time.
Thank you.
May it please the court. Good morning, Judge Goss, Judge Perkins, and Judge Brown. I am Henry Stein. I represent the plaintiffs, Marketing Support Services Incorporated, and the principals by the last name of Stevens. It is a father, now deceased, and two sons who are the plaintiffs. The arguments you have just heard are predicated upon multiple false assumptions, which will necessarily lead to an erroneous conclusion. And let me tick off what in reality has occurred, the evidence the trial court heard, and the reason Judge Martin entered an injunction, which of course is subject to an abuse of discretion standard. The evidence was clear on a number of points. That is, under the industry standard that we're dealing with, and under the agreement between the parties, and I want to make clear in just a moment what that agreement was, because it's not as portrayed by appellant's counsel. Under the standards of the industry, when an independent salesperson sells a particular service, particular account to a customer, in this case, we're not talking about, Judge Brown's home or Judge Perkins' home or Judge Goss's home. We're talking large companies such as American Airlines or its predecessors. We're talking school districts. We're talking large commercial consumers that generate thousands of dollars, if not many thousands of dollars per month in commissions. The industry standard is once that account is sold, it is the proverbial gift that keeps on giving. So if an independent sales agent sells an account in 1995, and that account is an account today, what is that, 25 years later, commissions flow during the entirety of that business relationship. In fact, even if there are add-on services to that account, that is a commissionable event, and the evidence demonstrated that the plaintiffs would be entitled to receive those commissions. It is not the accounts which are owned by the plaintiffs. It is the right to receive commissions. And that right vested when the account was sold, when those particular services were sold, whether it be last year, last month, last 5 years, last 10 years, or the last 25 years. So the plaintiffs have a property interest, an ownership interest in receiving a stream of payments commencing from date the account was created up until the time an account terminates, leaves CenturyLink, converts to an entirely different technology. The plaintiff, as the selling force, gets that money. Now, what was the...
Let me...
Pardon me?
Because you said the magic word, get that money.
Correct.
So let's say I'm with you on all of it. I think you're headed towards a big win. I'm just hypothetically. And you're gonna make that touchdown and win the game. How is it not all that you're asking for is money, which is not something that we do a preliminary injunction for?
Because that is the wrong, I'm not criticizing the question, but that's the wrong perspective. And let me explain. Because I started saying this is my client's property, their right to receive it. It is their ownership interest. And what I believe the judge did, and it is found in the findings in the preliminary injunction itself, is this is not a case primarily of breach of contract. This is a case primarily of conversion. And it is not merely historic conversion. It is a case of continuing conversion, a continuing tort.
Well, let me say I accept that.
Okay.
Do you have any case where a preliminary injunction has issued in a tort of conversion for money?
I have a case, and we've cited those authorities we could locate. There are cases for the proposition that where there is a continuing tort, that a court under its equitable authority can enter an injunction to prevent future or continuing harms. That is what is going on here. I am sensitive to that question, and I wish I could tell you there's an Arizona Supreme Court case decided 3 months ago that says what I would like it to say. I don't have that case. But what I do have is a recognition by the authorities, and we've cited cases for the proposition that a defendant who deprives one of their property rights, that is a continuing tort. Bearing in mind, the injunction did not require the defendant to disgorge money it received in the past. What the injunction did was say, we are going to arrest continuing wrongful conduct. That continuing wrongful conduct was the defendants, the appellants here, taking money that for 2.5 years of their relationship was routinely, regularly paid and remitted to the plaintiffs. Now, let me focus in on what the contract is, because there is misdirection afoot. There is slight...
Before we leave this
Yes.
topic, let me just clarify something. So I understand that you're using the term property and that you've avoided the use of the term money as much as possible. But at the end of the day, if your clients succeed, is counsel wrong that this amounts to a money judgment?
We are asking in our prayer for relief a variety of forms of judgment, including money damages, including injunctive relief, including statutory damages.
But the injunctive relief is as to future money damages. So ultimately, all of the relief amounts to money.
I argue with future money damages. I'd rather say it is property that is at issue.
Well, I understand why you'd rather say that, because it helps your client in the case law. But
and it happens to be property, which is money. But that doesn't necessarily mean...
So the cases that you've pointed us to with the ongoing torts or the
Right.
future damages or future tort damages that refer to property, which of those cases involve property that is money?
That's a very good question, and I wish I had an answer. I have not located a particular case that will, if I did, I would certainly cite it, and I would remind the court of that case more than one time, particularly if it arose from Arizona. I do not have that case. What I do have, though...
Can I, before you move
Yes.
off of that, and counsel has stated, and seems to be accurate, that there is no ongoing business that's being harmed.
Well, but that's a chicken and egg problem. The source of money for which this business operates is the stream of commission. And even though the main rainmaker in this matter, Tim Stevens, passed away on October 1 of 2018, which is almost to the day when the payments, the valve shut off from the defendants, they can't operate business because this is a business that's predicated upon the revenues they have earned, their property that has been diverted, has been converted from their ownership to the defendants.
So are you saying, counsel, that this put them out of business?
It certainly...
Or it's going to put... Okay.
It certainly has. They're not in business. The surviving son, Mark Stevens, did operate the business, and for two reasons. One is Mr. Finner's office demanded pre-litigation that my clients have no contact with any of the customers or clientele, And the fact of the matter is the spigot has been shut off.
But under this injunction, the spigot doesn't turn back on for your clients. It flows into the court. So the injunction doesn't actually resolve that, does it?
Well, it does, but it doesn't. It certainly preserves and protects my client's property from further conversion, from further access.
It doesn't help them run a business.
It does not help them today open up the doors. But it is the judge in this matter, Judge Daniel Martin, I believe, felt that under the circumstances where my clients earn this money, think of an escrow account. Think of the duties of an escrow agent to that of the defendant, Jago. They get the money in under their deal, and their deal isn't that my client renders services. The contract, the oral agreement is very narrow and limited. And that oral agreement is...
You have 10 minutes left.
Thank you. And that oral agreement is that money come in from whatever sources upon high, and that money is then divided, 80% to my client, 20% to Jago, for their whatever administrative work they have. That's the agreement. So when we speak in terms of what is the contract, what is the oral agreement, it is the agreement whereby Jago will be, think of an escrow agent, think of a company that receives my client's property and forwards it on to them once a month. And what is critical, and this is evidence that was, yes, Your Honor.
Well, let's say we go along with you, how does this not turn every contract case where payments are owed into a preliminary injunction case first?
Because this is not monies that are owed. This is monies that belong to my client that have been diverted. It is not a situation...
Isn't that the argument in every contract case? My client is owed this money.
No, sir.
And ladies and gentlemen of the jury, award my client the money they're owed.
No, sir. It's different. My client's entitlement to this money occurred years, if not decades earlier. It's their property. It is their property. Think of an escrow agent who has received money, and their sole job in the world is to disperse money in accordance with the party's directions. Same concept here. Jago's responsibility was to receive $1 in and remit 80 cents to my client. That was their job. That was the contract. Not for my client to render service. This is not a creditor-debtor relationship. This is a relationship where Jago became the holder as a conduit for monies to be paid to my client. And what the evidence demonstrated, that from November of 2016 through October of 2018, call it 2 years or thereabouts, every month, every single month, without exception, monies were paid on the order of $20,000 a month. It adds up to $275,000 plus over that period of time. I'm sorry, $475,000 over that period of time, where Jago would do what it was supposed to do. Jago would get out its checkbook, literally at first, electronically towards the end, and remit to my clients their share of the income, their property. They would remit my client's property to my clients. Plus, they would provide detailed, itemized, by account. They go on for pages and pages, and it's part of the record, how these monies were computed. And almost to the penny every month, the checks or the electronic transfers were made to my client of their property. That is Jago's job. It wasn't to compensate my client for services rendered. It wasn't to pay for ongoing efforts. It was there for one purpose, and that is in recognition of sales made by my client. That was the evidence presented to the trial court. That money came in, money was divided. Then, unfortunately, upon Tim Stevens' death, as I mentioned, October 1 of 2018, The last payment received was October 3rd of 2018 by Jago to the plaintiffs, and thereafter, the defendants have stuck the plaintiffs' money squarely in their pockets. They're in possession of my client's property. They have been in possession of my client's property since November of 2018. And starting with the injunction that was entered on January 10th of 2020, the court ordered the defendant to pay over to the clerk of the court, and I believe that's probably in recognition of exactly what the defendant is suggesting. Well, hold on a second, these are our commissions. Well, the judge made an equitable determination, once again subject to an abuse of discretion standard, and ordered these funds be sequestered pending ultimate trial and merit. This case is ongoing, and we're not at a post-judgment phase. But let's divorce the notion that this is money which is owed. This is my client's property, which has been converted, and Judge Martin ordered that that money be set aside pending ultimate resolution. Now, there was an argument about Rule 65. As I read Rule 65, it requires as a condition for entry of an injunction the posting of money if ordered by the court, or in an amount ordered by the court. We lodged a proposed form of order that does not include any bonding requirement. That was an exhibit to closing arguments that were filed with the trial court, and they were filed on November 13th of 2019. Exhibit C to that item include a proposed form of order. At no point did the defendant object to the proposed form of order. At no point did the defendant ask the judge to set a bond in connection with the preliminary injunction. That issue was raised in their closing arguments, but Judge Martin ultimately entered that order without objection from the defendant. So, focus, Your Honors.
Let me ask you this.
Of course, Your Honor.
Just in going back then, let's say we buy your argument again that this is property, not money. Where are the other findings to support a preliminary injunction? Where did the judge say, I find the strong likelihood that there's the possibility of irreparable damage, that the balance of hardships favors your client, and public policy would support this injunction? Where is that in the order?
It's on paragraphs 1 and 2.
That it actually says all of those 4 points?
Plaintiffs will suffer immediate irreparable harm, etc. Describes the injury. Plaintiff may be without an adequate remedy.
But what supports that? Saying those couple of words, what do we have in the record that the trial court, for example, in the transcript, the trial court doesn't say because of this, because of that.
Right.
It's just a simple recitation of what the law is, but nothing that we can read to support.
Well, there was significant, and the transcript of the November 1, 2019 hearing is part of the record, and there was significant testimony as to the hardships. There was significant testimony addressing each of the points that are underpinnings for preliminary injunctive relief. I don't have the page and line number references handy, but I was counsel for the plaintiff in that. I can avow that those issues were indeed addressed. Did the judge make particular findings? No, none were required, none were requested, but the fact the judge entered a preliminary injunction is evidence itself that the court found proper cause for entry of a preliminary injunction. So it is not, if a party had requested particular findings of fact, conclusions of law, then certainly we would expect to find particular findings and conclusions. That's not mandatory, but the fact Judge Martin entered a preliminary injunction.
But that really is all we have.
You have 1 minute.
Thank you, Your Honor. We, in terms of something expressly stated by the court, yes. In
And the
terms
judge
of,
never told us in terms of why he might have found this to be property. That's not clear in the record anywhere.
well, I think it's clear based upon the testimony and based upon the arguments, but in terms of the judge issuing a minute entry order or entering particular findings or stating on the record, I am at a loss to provide that because I don't believe that exists, at least not that I can recall, Your Honor. But bottom line, injunctive relief is equitable relief. The judge found it fair, equitable, and appropriate to sequester these funds that are my client's property pending an ultimate resolution of the case. That is supported by the evidence, it's supported by the law, and this court on an abuse of discretion standard should affirm. I think my time is up. Thank you. Thank you, Your Honor.
Counsel.
Just a few points I'd like to touch on, Your Honors. Now, in response to questions from the court, plaintiff's counsel was asked, when you say damages, what do you mean? Money. When you say property, what do you really mean? Money. There can't be any good faith dispute that what we're talking about is monetary damages, and I think that's very important because the reversible error in this case is that the trial court has entered an order that doesn't follow existing Arizona law. I don't see that there's no argument that's been raised by the plaintiffs to get around that. Nothing I've heard. And I want to clarify a few things. What plaintiff's counsel said is, my clients are entitled to compensation from now to the end of time, not because of something, again, that they did for Jago Holdings, but because they performed work pursuant to an agreement with Alpha Communications, then later Vital Telecommunications, and somehow, after those accounts are transferred over to Intelisys and Jago Holdings enters into a written agreement with Intelisys to do the work, we are somehow now entitled to a never-ending flow of commissions from Jago Holdings. That makes absolutely no sense, and there is no legal basis for that argument. And with regard to their contention that somehow this has put them out of business, well, that ignores the actual testimony given at the hearing, as well as their subsequent deposition testimony. There's no dispute that my client, Jago Holdings, and Jared White had a long-time relationship with Tim Stevens. Tim Stevens is deceased. My client has no interest in helping to support his, and I want to say this respectfully, not terribly financially successful adult children for the rest of their lives who have no knowledge of the telecommunications industry, no relationship with anyone in the industry, and no ability to sell or do anything. And frankly, that's what's going on here. And with regard to this analogy of an escrow agent, that's the worst analogy ever. An escrow agent is holding someone else's money and has no obligation to do anything other than to disperse funds in accordance with the instructions you receive. That's all an escrow agent does. That's not the evidence before this court. The evidence before this court is Jago Holdings is the only one who actually does anything. The plaintiffs do nothing, have no ability to do anything. So the whole analogy to an escrow agent is just wrong, because the only one who has placed any orders is Jago Holdings. The only one who has any relationship with any of these CenturyLink customers is Jago Holdings. And in fact, the plaintiffs couldn't even identify for me who the contact for any of these companies would be. They don't even know who you would contact at the company if they wanted to discuss telecommunications services. So the notion that somehow they've been put out of business is just completely false. There is no business. They cannot transact business. They don't have the knowledge, skill, ability, or relationship to simply transact any business. And again, the plaintiff should not be allowed to utilize this preliminary injunction as a tactical weapon to make it more difficult for the defendant to fund its defense of their claims in this case. That's not the purpose of an injunction. And it's not to help the plaintiffs in the event that they were ultimately somehow successful in this case collect. That is not the purpose of an injunction. I don't think there's any dispute that monetary damages are not an irreparable injury, and that's the only injury that they've identified for purpose of the preliminary injunction hearing. So I think under well-established Arizona law, there is no way for the court to find that it was not reversible error to enter the preliminary injunction in this case. all I have.
Thank you, counsel. We'll take the matter under advisement, and the court will stand in recess while we reset for the next argument.
Thank you.